Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Okay. Oh, okay. Okay. Good morning. Are you Ronnie Green III? And Mr. Green, we have 23 DCCR 1502 and 24 DCCR 1320. Mr. Green is on probation for possession of a prohibited weapon and possession of marijuana. Motion to revoke probations have been filed in those two cases. There's a new indictment in cause number 25 DCCR 0735. Mr. Green is charged with money laundering. Mr. Galmore has filed writs asking that I set bonds in those two MTRP cases. He is on deferred probation, so generally entitled to a bond, but based on the nature of those offenses and that new offense, I wanted to have a hearing and get the state's input on their position on bond amounts, and bond conditions.
The state's filed a reply to the writ that was filed by Mr. Gilmore. I don't know if you had an opportunity to see that or I've kind of laid out the state's argument.
Okay.
In that reply.
Let me look at it real quick. I feel like I might have seen it, but I've slept since then, so give me a second to.
Judge, I don't know if you see letters in there as well. There's been letters that have been supplied to the court.
Okay, I'll take a look at all of that. I don't know. Do I have any of that over there? Anything printed out on him? Some of that sounded familiar. Yes, okay, so I saw the letters.
Yeah.
I can summarize it for you, Judge.
Okay, the letters I got. Brandon, let me look at this real quick. Now this is looking familiar as well. So yeah. And I recall now what you filed also with regard to some requests, and we'll get that set for the appropriate time, Mr. Coleman, as far as modifying bond conditions and things like that. And I guess you've seen those.
Absolutely.
I don't know if y'all want to talk about that, if there's some agreement or not. But for this morning, Mr. Galmore, I guess you can just make argument or.
Yes, Judge. I would just like to summarize a few things real quick. He is on probation for two cases. They are different offense dates, but I want to point out that he did not receive probation and then pick up a new case. These were the situation where he received probation and there was an older case that just simply not been filed yet. Since he's been on probation, there has not been the commission of any new offenses other than the offenses we're talking about today. I will say that he's been in jail for 20 days, which is longer than any other time that he's ever been arrested before. I did have discussions with the state today about a possible resolution that would involve Mr. Green going to ISF and not revoking his probation. And that sounds like a reasonable outcome. I have not had an opportunity to review the discovery in the new case, and so I don't feel like I'm in a position yet to advise my client on what would be the best option as far as that's concerned. I would point out that in the letters, there's one thing that really kind of struck a chord with me, is that since this alleged offense of the money laundering, which was earlier this year, Mr. Green has really taken a lot of efforts in his life to start walking the correct path. He became more involved in his church. He was baptized since the alleged commission of this offense. He's got a lot of family support. His mother is here in court today on his behalf. And so what we're just simply asking the court to do is set reasonable bonds. He is on deferred. And even though there is a new offense, I would say that the majority of all motions to revoke probations are based on illegal activity. Even if it's not a new offense that was committed, it's alleged. Very common is a failed drug test. And obviously if you're failing a drug test, you're committing a crime at some point, possessing that illegal drug. And so We're just simply asking the court to set reasonable bonds. I believe reasonable bonds in this scenario would be about $10,000 on each case. I believe the government is asking for $50,000 in their motion.
Your Honor, and Mr. Galmer and I agreed that we were both asking the court to set reasonable bonds. My version of what's reasonable, given the fact that less than 1 year since the defendant was placed on 2 deferred adjudications, he's out allegedly committing money laundering. If the allegations are proven true, that money laundering, those proceeds constitute proceeds from drug trafficking or delivering controlled substances, Judge. The opportunity, as Mr. Galmo put it, to walk the right path, the correct path, came back in 2024 when this court put him on probation for possessing a weapon that was outfitted with Glock switch. My version of what a reasonable bond should be in light of this defendant's actions is no less than $50,000 in each case, Judge.
So if there is well, 2 things with regard to what you're talking about. One is, depending on whether or not the allegations were proven true, and if there was some thought of continuing Mr. Green on his probations and getting a probation on that new case, the only way I would go along with something like that would be for ISF, some type of cognitive program in custody. And while I understand and appreciate that he's making some strides on his own, from a legal standpoint, it doesn't make a whole lot of sense for him to be back out and then go right back in to ISF. The point of ISF is to get that done so that when you get out, you've got better tools to make better decisions so that you don't end up in prison for, I mean, you're looking at prison up to 10 years on those 2 cases, and then you've got the new money laundering case. So
To address that, just real quick, Judge, the money laundering case, I've only been on the case for approximately 2 weeks.
right.
Speaking with Mr. Green, he states that he does have proof for a lot of the money, so I don't think at this point I can even advise him that agreeing to a deal where he goes ISF when that's the only violation is the appropriate route. Of course, with him being in jail, it's a lot harder for him to assist in his own defense of that case.
And Judge, of course, the state has a different position on the proceeds or where those funds were derived from and our ability to prove where they came from.
Let me look at something real quick. I guess I'm just taking a look at the probable cause affidavit on the money laundering, just to get an idea of what those facts are. I think I have a little bit of them the facts, obviously, from Mr. Coleman's response to your request, but let me look at this real quick. Actually, I can't read it. I'm printing something. Maybe.
Maybe.
It's a long way for it to go from here to there. Okay, how long, obviously you need some time, Mr. Galmore, but how quickly could you get up to speed on the money laundering?
It wouldn't take me very long to get up to speed on the discovery and watching the videos, but it'd be substantially more difficult to try to track down financial records for Mr. Green while he's incarcerated in the Jefferson County Jail, which is one of the reasons why we're asking for bonds, so they can assist in that part of his defense.
Your Honor, I would offer this. When interviewed by the law enforcement, the defendant indicated that he had no records that would show the source of the proceeds they received.
That you're correct, that's what I see as well, other than maybe one social media post on Instagram.
It appears on the roadside discussions about the sources of money that Mr. Green did not have a lot of answers necessarily, but I would say that on the side of the road, and the question about.
Well, I think they brought him in and Mirandized him, right? Once at the jail, read Miranda warnings, waived his rights, and during the interview, couldn't explain how he obtained it, advised he sold one French bulldog late last year for $1,500, but nothing else. Didn't have a job. One Cash App thing he could show for that one dog. So,
I haven't seen that video
Yeah.
yet. I'm assuming it's video recorded, it's supposed to.
it should be, yeah.
I just haven't had an opportunity to review that video. I do know that there was a car wreck where he received a settlement from that car wreck, so there were some additional funds that weren't discussed. But again, I don't have access to those records as of yet.
Okay. All right, so what I'm going to do is grant the relief requested in 23-1502, set the bond in that case at $35,000. In 24 DCCR 1320, also set the bond at $35,000 in that case. I'm going to order as a condition of both of those cases that Mr. Green remain in Jefferson County, also that he wear a GPS monitoring device at all times, and then we will reset the case for a status at just in normal 30 days or so. Okay?
Would the court believe or think that a curfew would also be appropriate?
He's on probation, so he has a curfew.
All the standard conditions.
All the standard, you're still on probation, so if you make these bonds, all your regular conditions apply, but now there's the GPS monitoring device and a remain in Jefferson County also as a condition of your bond, not just your probation. Okay? All right.
Thank you, Judge.